All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The Constitution of the State of North Carolina says that the Supreme Court will meet in Raleigh or such other places designated by the General Assembly. To honor the restoration and reopening of this courthouse in 2004, the General Assembly, by statute, says that the Supreme Court can now meet in Edenton. We are grateful for the times that we are here. It's been 5 years since we have held court here, so it's a treat for us to be back. We certainly welcome this morning students from John A. Holmes High School as well as Lawrence Academy. So welcome students and welcome all. The first case that we have this morning is Cedarbrook Residential Center versus NC Department of Health and Human Services, and we will hear from the appellant.
Good morning. I'm Door with Robinson Bradshaw. I'm here with my colleague Demi Bastian. We represent the defendant appellant, the North Carolina Department of Health and Human Services Adult Care Licensure Section. I'd like to reserve 5 minutes. The plaintiffs are asking this court to hold that they can pursue a tort claim against the department by alleging that it was negligent in regulating Cedarbrook, an adult care home in Nebo, North Carolina. The legislature mandates that the department regulate adult care homes like Cedarbrook to protect their vulnerable residents. Elderly people, people with disabilities or mental illness, these are the residents of adult care homes. And the General Assembly has expressly expressed its intent to promote their interests and well-being. During inspections in 2015 and 2016, the department found that conditions at Cedarbrook were detrimental to the health and safety of residents, and that Cedarbrook was failing to protect these people from abuse, neglect, and exploitation. The statements of deficiencies ran to hundreds of pages, including issues with roaches, a resident who intentionally started a fire in a residence hall bathroom, and failing to ensure that residents with diminished mental capacity were engaging in sex safely and with consent. The General Assembly requires the department to act when it finds violations of laws passed to protect residents, including the Adult Care Home Residents' Bill of Rights. For example, Section 131D24 says the department shall impose an administrative penalty for violations. The department can also suspend admissions of new residents by statute, where the conditions of the adult care home are, quote, detrimental to the health or safety of the residents.
What about in a situation like this where it appears that Cedarbrook is arguing that given the nature of the individuals who are there, their various challenged capacities, that even the interviewing process, the information gathering, all of this that took place was, one, detrimental to the folks that were there, but secondly, that the DHH turned a blind eye to uh, to be willing to listen to the explanations by Cedarbrook with regard to the various things that were found. I mean, does the department have a responsibility to not just conduct interviews with folks that may have diminished capacity, but in fact to consult with the actual caregivers as well?
So I'll take your question in two parts, Your Honor. Question of whether the inspection and the activities of the are detrimental to the residents. Cedarbrook is not asserting claims in the name of the residents, and that's really a key distinction here between a tort claim brought on behalf of somebody who's a tort victim, as in the sense of a regulatory failure, where there was somebody who was, there wasn't an inspection done and somebody was injured because the conditions at the facility were unsafe. So Cedarbrook isn't asserting that kind of claim here, nor could it. On the question of whether the regulators owe a duty to the facility or whether they should not have turned a blind eye, as Cedarbrook alleges, of course we dispute that, to explanations or mitigating factors for the violations, of course the department should exercise its statutory authorities with as much diligence and care as possible, including communicating with the facility and the people who are there working in it. But if there's a dispute that arises out of that process, the General Assembly has clearly said that those disputes go to the Office of Administrative Hearings to be heard by an administrative law judge. And specifically, in the statutes governing issues like suspensions of admissions, imposition of penalties, those statutes say that if the adult care home wishes to challenge, it should file a contested case. The contested case doesn't provide an opportunity for the adult care home to obtain money damages.
What's your position on the dissent's view that OAH, the Office of Administrative Hearings, would have exclusive authority to handle a matter such as this one as opposed to the Industrial Commission?
That's entirely consistent with the department's position here, Your Honor. Our position is that the administrative law, this case is particularly challenging and novel because it involves the intersection of administrative law and tort law. And what Cedarbrook is attempting to do is create a new form of administrative law tort where you can sue for negligence in the process of pursuing responsibilities under administrative law, like inspections, suspensions of admissions, things like that. That's a totally separate thread from tort law, which is for tort victims. And, in the situation where there's a tort victim who's injured by the negligence of a state employee, that goes to the Industrial Commission. But our position is that when Cedarbrook filed its claim in the Office of Administrative Hearings using the remedies expressly provided by statute, that should have been the end of it. And that in this claim, where you're combining these tort systems and this administrative law systems, that it could lead to massive confusion. And that really there's no situation in which somebody who's regulated by the state couldn't claim that their regulator was negligent.
And I think if I understand your colleague's argument correctly, and they're going to have time to tell me that I didn't if I don't, their argument seems to be that essentially tort is inevitably involved in this situation because essentially everybody owes a basic duty of care to everybody else, and that there's nothing that would accept a state agency like your client from the general duty to exercise due care. What response would you make to that argument, assuming that that's the one that they're making? Because that means ultimately the first of your arguments is there's no duty. They say everybody's got a duty.
Yes, they do. And our position is that if you draw the duty with that level of generality, I think the concurring opinion in the Court of Appeals referred to it as a universal duty of care. It would apply to literally every action that every state employee takes in any context, including, executing the laws passed by the General Assembly. If this claim is allowed to proceed, for example, take a claim in the Industrial Commission. If the Industrial Commission owes a duty to act reasonably or consider certain evidence or consult in particular ways in making its decision, if this claim is recognized, there's nothing to stop a disappointed utility company from saying that a rate-setting decision was negligent and file a claim in the Industrial Commission.
Well, let's protect the Industrial Commission there. I think they get workers' comp, and my former body, the Utilities Commission, gets rates. But I mean, I take your point. I mean, your point, I gather, is that if when I was the Utilities Commissioner, I had negligently decided a rate case, that would be subject to tort. You don't think it should have been the case?
Absolutely, Your Honor. And I think it's quite clear.
And just tell me one more time why, so that I'll follow you correctly.
Okay. I think there are multiple reasons why the employee acting for the state in this kind of context, and particularly when there's an express remedy to the Office of Administrative Hearings, would not be able to pursue a tort claim. The first is the Assembly clearly contemplated the remedies that would be available in a situation like this. For example, if there's a penalty and it's determined to be unreasonable on an adult care home, that's the statutory language, an unreasonable penalty. The remedy for that in the same statute is that the administrative law judge can adjust it. And I think that it would be a huge distortion of the General Assembly's plan to deal with these kinds of regulatory disputes if the party could then file a whole new action in the Industrial Commission after resolution of the Office of Administrative Hearings case and say, well, that was unreasonable. So in addition to adjusting the penalty under the Tort Claims Act, we can also pursue a claim for money damages here in this separate forum.
Well, you've candidly admitted, and I'm using your phrase, that there's an intersection between a tort action here and a regulatory action here. Are you saying the OAH has exclusive control, or is there any place for a resolution of this nature by the Industrial Commission?
I'm saying when the General Assembly has provided an express remedy to the Office of Administrative Hearings, that is exclusive. And that, you might have, that's not to say that you couldn't conceivably have a tort action in some kind of situation where it's related to negligence, right? Like if Mr. Leonard, who's also a plaintiff in this action and owns Cedarbrook, came to the DHHS offices for a meeting about his protest or to try and negotiate a resolution with regulators and slipped and fell in the water, that might be a tort claim. Or if the department regulator drives out to Cedarbrook, forgets to set the parking brake on the car, and it rolls into a building, maybe you could have a tort claim for property damage there. But that's an entirely separate context from the specific regulatory actions here, where the department is carrying out specific statutory responsibilities to inspect and license these adult care homes. And that's the situation where there's no duty.
So
I'm sorry.
Rita,
Could I ask one more?
please.
All right, thank you. Are you agreeing then with the dissent's position that since a private person does not have regulatory authority, that therefore, again, there's this exclusivity in terms of looking at the fact that the State Tort Claims Act would not be available because of the fact that private persons don't have regulatory authority? Or is there some other way to look at this aside from how the dissent pictures it?
That's certainly an important aspect of this. There are a lot of other challenges with Cedarbrook's claim, but yes, the private person language in the Tort Claims Act does deal with this issue. And it speaks to the scope of the state's waiver of sovereign immunity when it passed the Tort Claims Act, which was limited to circumstances where a private person might be liable. And so what this General Assembly, and it's very clear from all the legislative history and all the prior case law, the General Assembly was trying to put tort victims injured by the negligence of a state employee in the same position as regular citizens. So if you were in a car accident and you were injured or your car was wrecked, you can file a tort claim regardless of whether the person driving the car happened to be an employee. And all of the early cases involve those kinds of situations, and that reflects the scope of the waiver. The General Assembly did not intend the scope of the waiver to extend to these kinds of actions.
That, I want to follow up on that.
Of course.
Is it your primary contention, based on the factual scenario alleged here, General Assembly in the Tort Claims Act just didn't provide for this kind of tort, or that the allegations here don't really allege a tort, or that the public duty doctrine applies to bar it, or all of the above?
Yes, Your Honor. I'll take option D, the above. It does. All of those are reasons why this claim cannot proceed. And I think they all illustrate how trying to smush these two separate laws together, tort law and administrative law, creates all these complicated challenges and problems. I think that's also true, in addition to the duty element of a negligence claim, for the cause element. If the department is required to enforce statutes and impose penalties, did it cause damages? And then should we go into the Industrial Commission and have disputes about, was there contributory negligence if the facility was understaffed? I mean, these are the kinds of abstruse, complicated issues that you get into if you try and transport or layer tort law on top of administrative law, and it doesn't make any sense, and it would be dangerous to the whole regulatory structure of the state.
Do you think it's necessary to talk about the public duty doctrine?
I don't think it's necessary to talk about the public duty doctrine to resolve this case. I think that this case could be resolved simply on sovereign immunity by saying that this court has repeatedly held that sovereign immunity isn't waived absent a plain, positive legislative direction to that effect. And that when you look at the statutes governing adult care homes and you look at the Tort Claims Act, there's no positive declaration that the state consented to be sued here. So I think you could resolve it on that ground. I think it could also be resolved on any of the elements of a negligence claim, because without a negligence claim, it doesn't fall within the limited waiver in the Tort Claims Act. And I think, we've talked about duty, we've talked about breach. Cause also creates all kinds of problems and doesn't fit here. And then damages.
Well, and if you get into duty, you get into public duty doctrine, possibly.
I believe that public duty doctrine is an affirmative defense. And I think that that's one of the things that the Court of Appeals here made, was that it said that because the public duty doctrine didn't apply, therefore there was a duty. And I think that's backwards in the analysis. I think the first question is there a tort claim? And then I think the second question, which is discrete, is there the affirmative defense of a public duty doctrine?
Does it matter for purposes of your overall argument that the plaintiffs here did pursue the administrative appeal of the regulatory action?
Well, I think the way that matters is that they filed the regulatory challenge in the Office of Administrative Hearings using the remedy provided, and then that case settled. And our position is that that's the function of administrative law. It's designed to resolve disputes like these. And it shouldn't then turn into a whole separate tort law action in a separate forum where you would litigate the same issues. I mean, there was discovery, depositions, all of that in the Office of Administrative Hearings. And it would be incredibly judicially inefficient to then turn around and litigate those exact same issues in the Industrial Commission. And our position is that that's in no way what the General Assembly intended.
And Counselor, to follow up on the negligence claim issue, I believe it was your brief that cited albeit a Court of Appeals case, that related to negligence interference with contract. What I'm struggling with is there even a recognized tort in North Carolina? Could you comment on the Williams case and whether you see this as even a recognized tort?
We don't see the claim that Cedarbrook is attempting to bring as a recognized claim. And I think in the Williams case, it was another case where a party was trying to challenge state administrative type decision using a negligence court rejected that, I think using similar rationale to what we would suggest here. And there are other Court of Appeals cases that have taken the same approach in the past. And a lot of those cases have focused on the idea that, tort is the law of accidents. And that when you have a regulator acting intentionally enforcing state law, that doesn't fit that rubric. And so I think you're correct that in the Williams case, that there's a question about whether the claim exists in the first place, but I think the court is also analyzing and grappling with the intersection of tort and regulatory law and rejecting that claim.
And then a follow-up with respect to the particular facts in that case, and as they compare to this case, we have Williams is about a negligence interference with contract. How would we see that as an interference of contract here? How is it analogous other than just the more general prospect, or is it more specifically analogous?
I don't think it's analogous in the sense that Cedarbrook isn't attempting to bring a negligent interference with contract case. I think if their claim was recognized, there wouldn't be anything to stop them from doing that. For example, some of the damages that they claim here are that Mr. Leonard planned to sell Cedarbrook and that he would have earned a profit on that sale, and that because the department was engaged in regulatory action, the sale fell through. So if he had already executed a sale contract, I think that would have been very similar to the negligence claim that he's making here about the activities that the department took and how those affected his business. So I think that's this back and forth illustrates the central problem with these kinds of claims is that there's no real stopping point and there's no developed law to address them because tort has never really applied in these areas. And I think that's why the Court of Appeals decisions that it made prior to Cedarbrook, like Williams and like some older cases involving the state bar, they said this kind of intentional regulatory action by the state doesn't fit within a negligence claim because when the state acts, it does so with purpose. This is 8 employees named in the affidavit. It wasn't an accident that they inspected Cedarbrook over a period of 10 months and issued these violations.
Can I ask you along those lines on the question of whether there's a negligence claim here, then what we should do with the Nanny's Corner case? Because the dissent says, well, just limit that to the statute of limitations issue. But as I understand it, the claim there was that the agency negligently relied on didn't do its own investigation when it found the violation and then it issued penalties or made the daycare do certain things. As I read that opinion, apart from the question of what our denial of the appeal means, just on what the opinion itself says, it very clearly says that in those circumstances, there's a claim in the Industrial Commission.
Yes, Your Honor, it does say that. And I think there are 2 ways that this court could deal with Nanny's Corner. One would be that if you look at the Nanny's Corner decision, that it very clearly says right before it goes into the statute of limitations analysis that the statute of limitations disposes of the claim, but nonetheless we proceed to briefly address this question. And so I think it would be appropriate and consistent with that court's decision to confine that case and say that the remaining piece is dicta. Of course, the court could also overrule the Nanny's Corner decision to the extent that it says that there is a claim like the one that Cedarbrook is attempting to bring here. And I think that when
there has to be
excuse me, Your Honor.
you've got a constitutional tort, perhaps, and in order to avoid the constitutional tort, there had to be a finding that there was a statutory remedy to prevent going to the constitutional tort. So aren't we gonna, if we say, well, we're gonna limit Nanny's Corner to the idea that there was just a statute of limitations, don't we open up again the possibility of a constitutional tort?
So the statute of limitations analysis in Nanny's Corner doesn't cross over entirely with the question of the constitutional claim. And it actually, if you read the section that addresses the statute of limitations, it says that the statute of limitations began to run when the claim was filed in the Office of Administrative Hearings because there was no money damages remedy. It doesn't say that there had to be a money damages remedy, and there is no reason that the court would have had to decide that question to deal with the statute of limitations issue. And as far as this broader question of whether holding that that there's no negligence claim here could lead to constitutional claims, that's an argument that the appellee has raised in its brief in this court for the first time. But to the extent the court wishes to address it, our position would be that that's a separate case, that Cedarbrook didn't attempt to bring a constitutional claim, and that there are complicated questions surrounding those kinds of quorum claims. And there's a whole body of precedent, decision in quorum in 1992 that has evolved to address that. And so if there's going to be a sense that there needs to be some kind of remedy, notwithstanding the General Assembly's statutes that it's passed without a money damages remedy, that our position is that would be, a question for this court to address and develop in future cases, not here. I see that I'm almost out of time. Unless anyone has further questions, I'll reserve. Thank you.
We'll hear from the appellee.
May it please the court, I'm Joseph Ponzi with Brooks Pierce, counsel for the plaintiffs, Cedarbrook Residential Center, and Fred Leonard, and with me is Howard Williams. The adult care licensure section, ACLS, tries to paint Cedarbrook's claim as extraordinary. It does so by ignoring the facts of this case. The claim is really quite simple. The adult care licensure section negligently undertook inspections and summary licensure actions against Cedarbrook, an adult care home in Western North Carolina, damaging Cedarbrook and its owner as a result. ACLS refuses to engage with the actual facts of this case, but the context for how we got here is important. The inspections themselves began in November of 2015, and the suspension of admissions was issued shortly thereafter. Now, the suspension of admissions prevents a facility from admitting new residents. Given the nature of these facilities, which do have a high resident turnover, leaving that suspension in place over a period of time cuts off the revenue of the facility. It leaves it to die on the vine. Now, after each inspection, issued a statement of deficiencies, essentially their charging document. And in this case, those statements of deficiencies were hundreds of pages long. They were sprawling documents. We could not rebut or even understand what ACLS was alleging in those statements of deficiencies. So we filed suit in OAH, and we had to build a record first to get a remedy. We did that through discovery and depositions, and once we built that record, we sought a preliminary injunction. We obtained that preliminary injunction in July of 2016, but by that point, the damage was done. The resident census had dropped by more than half. It's worth noting, we were making the same arguments to ACLS on day one of their inspections as we were as of the time of the morning of trial. We wrote them a 27-page letter in January of 2016, outlining the various mistakes and errors that they had made. And rather than reconsider their tactics, they doubled down with more inspections and more licensure actions and more statements of deficiencies. That is what caused Cedarbrook's harm. Now, these are unusually well-developed facts for a motion to dismiss, and they have been tested. They were tested by the administrative law judge on the preliminary injunction, and he found that we had shown a likelihood of success on the merits. They've been tested by the Industrial Commission, the finder of fact for this case, who determined that we had alleged a claim for negligence. Our facts support that finding. Now, the agency attempts to sweep away those facts and characterize everything as regulatory action, But the details are worth understanding because it shows what kind of conduct and what kinds of consequences ACLS is actually trying to
Well,
excuse.
help me understand the scope of the tort claim that you're asking us to recognize. Hypothetically, I'm going to give you a couple of hypotheticals and just talk to me a bit about how your claim applies in these set of circumstances. A person is injured at work, files a claim with the Industrial Commission seeking workers' compensation benefits. Again, hypothetically, the commission goes through the proceedings, starts the proceedings, and then just makes an off-the-wall conclusion, either that no benefits were payable or that benefits were payable. And it's just a totally unsupported decision one way or the other. Is whoever is harmed by that decision, either the claimant or the carrier or the employer, if they're self-insured, entitled to bring a tort action under that set of circumstances?
No, I don't think so, Your Honor, because they have their own remedy through the appellate system that is set up from the Industrial Commission to the Court of
How
Appeals.
is that not true here too? I mean, my understanding is, and it's a big record and I may have missed something, and so please tell me if I did. But my understanding is that you initiated the OAH process was initiated, got to the point of actually having a contested case hearing, and then there was a settlement. Let's say hypothetically that instead of settling, the parties had tried the case out in front of the administrative law judge, and the administrative law judge reached a decision one way or the other as to whether what the agency did was within the scope of its lawful authority. At that point, assuming that they found that the agency did act lawfully, your client would have had a right of appeal at that point, right?
I'm sorry,
Your client would have had a right of appeal at that point.
That's correct.
So how is that any different than the much simpler workers' compensation hypothetical that I mentioned to you a minute ago?
Because our remedy in either case is established through the appeal process that is provided for by law.
But you instead of settling, you could have appealed
Well,
or gone to trial and appealed.
and on the morning of trial here, the agency withdrew all of the allegations.
And I guess, and that was something I was going to ask you about anyway. Your brief says that several times. If Mr. Doerr's brief addressed it, I didn't see it. Was that with, it's been a long time since I did anything in the OAH as an attorney. Was the withdrawal of those allegations part of the settlement, or was that something else?
No, it was part of the settlement that resolved the contested case.
All right.
Yes, Your Honor.
So in essence, as part of the withdrawal of the findings that you've referred to in your brief several times was part of the settlement that your client entered into with the agency.
Yes, that's exactly right. It was part of the settlement.
I'm having some difficulty understanding why the appeal is sufficient in the workers' comp hypothetical that I gave you, but it's not in this set of circumstances. Help me understand why there's a distinction that I'm not picking up on so far.
It's because it goes to the availability of relief. In this case,
Let me interrupt you to make sure I understand you. Is therefore, in theory, the comp claimant could either, if we're talking the comp claimant, the comp claimant would ultimately get benefits as the result of an appeal, or the company would be precluded from making a payment, whereas there's no similar remedy available here.
that's exactly
So
right.
is your argument in essence that this tort claim exists anytime that a regulated entity winds up being financially worse off as the result of a negligent regulatory decision?
No, our argument is that when an agency takes an action where OAH does not provide adequate relief, and this is not dissimilar from the
Relief would have to include some sort of financial compensation to the regulated entity?
in this case, certainly, given the summary nature of the licensure actions that imposed severe damages against the facility and Mr. Leonard before any relief could be had. So it's important to keep in mind that these were summary actions. The damage was done before Cedarbrook had any chance at relief.
Well, let me give you a different hypothetical then and see if this works. My knowledge of utility law is a little bit less rusty than it is of workers' compensation law, but hypothetically, a utility company applies to the commission for a general rate increase. The commission errs in favor of the consumer interest and against the company. I'm not sure whether the court has ever decided that a company that is harmed by a commission decision that doesn't set the rates high enough is entitled to a surcharge. I don't know that issue has ever been decided. Hypothetically, assuming that it isn't, so that the utilities rate are set too low, and even on appeal, they might get relief prospectively. They possibly would have been a period of time when they couldn't come back and get a surcharge. Would that utility be able to bring a tort claim against an individual member of the commission or the commission under the Tort Claims Act?
Well, certainly not against an individual member of the commission.
I realized as soon as I said that was not inconsistent with the Tort Claims Act, but it was too late to back up.
But the Tort Claims Act does impose a duty of care to proceed with reasonable care, again, to state agencies acting within the scope of their employment and authority. Now, it is unlikely as a factual matter.
But hypothetically, the answer to my question as you see it is yes, that such a tort claim would exist against the commission.
No, I think the relief there is through the appellate process provided for by law.
The appellate process in that instance hypothetically would not allow a surcharge picking up. I think this is an open question, so I'm assuming a legal answer that I don't know has been given yet, but assuming that the utility is not entitled to go back and get additional money from the customers as a result of the fact that it was not given sufficiently high rates, so that it didn't get the money and it doesn't have any way to go back and get it. Assuming all of that to be true when it may not be, is a tort claim available under that set of circumstances?
Your Honor, the Tort Claims Act imposes a duty of reasonable care on agencies acting within the scope of their employment and authority. If the Industrial Commission in that case failed to act with reasonable care and the claimant could prove that, potentially there would be an action under the Tort Claims Act.
Let me shift gears for just a second here about that particular thing you were just talking about, what the Tort Claims Act says about the duty of agents of the state. It also says that while acting within the scope of their office, employment, service, agency, or authority, and here's the key language, under circumstances where the state of North Carolina, if a private person, would be liable to the claimant. And as I understand, the state's argument is that a private person doesn't have the authority to regulate, and so therefore that clearly doesn't cover this type of situation. Otherwise, you would open the door to a flood of all kinds of claims against a ton of different regulatory agencies, like, the health department imposing downgrades on restaurants and publishing it in the newspaper. Can they all sue if they think the inspection was negligently done? But the point being that the Tort Claims Act is limited to actions by the state being subject to tort action if a private person would be liable in those circumstances. How could a private person be liable for regulatory action?
And the courts have spoken about that language. It doesn't limit tort claims to instances where a private person would have the authority to take the action that the state took. What it does is it is the waiver of sovereign immunity, and it incorporates the law of negligence. So it allows for the defenses that any private person would have, like contributory negligence or last clear chance. But
what
there are
specific authorities are you talking about? You said that the courts have said that this is allowed.
Patrick in particular speaks to the waiver, the private person language being the waiver of sovereign immunity. And there are numerous instances of Tort Claims Act cases involving the exercise of regulatory authority that private persons cannot take. This court's affirmed per curiam the decision in Watts v. Diener, which was a claim against Diener for negligent inspection and issuance of a septic permit. A private person does not have the authority to issue a septic permit. And the Court of Appeals found that was a cognizable claim This court affirmed it per curiam. The suggestion, of course, being that it is unremarkable that regulatory action can be subject to a Tort Claims Act and that the agencies undertaking that action owe a duty of care. Another example is multiple claimants v. DHS. Again, this court's opinion, which involved the negligent inspection of fire safety devices in a county jail. There too, the court recognized that claim. It was a cognizable tort under the Tort Claims Act. And then
Do any of the cases that you're relying on involve situations where the damage is economic to the business as opposed to the risk of possible physical damage to individuals or property?
Nanny's Corner was, of course, a case that related to economic damages. And I'm sorry, the name escapes me, but damages are part of the Tort Claims Act. It is claimants under the Tort Claims Act have the same right to direct and consequential damages as any claimant asserting a claim for negligence.
Well, do you disagree with your opponent's argument that in Nanny's Corner, the Court of Appeals majority says, we're disposing of this case on the statute of limitations, and then goes on to say, but anyway, you could have covered, this could have been remedied under the State Tort Claims Act, and that's dicta.
I do disagree with that, and so did the majority in the Court of Appeals in this case. That was part of the holding. They had to identify, they had to reach the decision that there had been a Tort Claims Act claim available in order to dispose of the case otherwise. So it was part of the holding of Nanny's Corner, and the Court of Appeals got it exactly right.
How does your litany of cases include the Ray case, Ray versus NCDOT, wherein there was the recognition of even a limited sovereign immunity for a state agency, particularly an employee or an agent within that state agency, and yet still it was deemed that that could only occur if a private person had the opportunity to be sued?
Well, Ray dealt with the public duty doctrine and the scope of the applicability of the public duty doctrine, and it was very clear on that point that the public duty doctrine is much more narrow than this court had previously held it to be under the 2008 amendment to the Tort Claims Act. And that was the hook of the private duty doctrine, of the public duty doctrine, I'm sorry. The theory behind it was that we didn't want to hold the state liable because of its status as a government. So where a private person didn't have authority to undertake that action, you can't hold the government liable because then it's liable for its status as a governmental actor rather than for its conduct. Here, we're not asking the court to hold ACLS liable for its status as a governmental actor, but rather for its conduct in undertaking negligent inspections and summary licensure actions against Cedarbrook.
So there is some reliance on the public duty doctrine, as I understand it, or are you detaching yourself from that to some extent?
Well, the public duty doctrine does not apply to this case. That is very clear under that 2008 amendment to the Tort Claims Act. It applies in two circumstances, and Ray affirmed this quite clearly. It applies if and only if the injury to the claimant is a result of the negligent failure by law enforcement to protect the claimant, or by the negligent failure of the state to perform a health or safety inspection. Those are both omissions. This case does not involve an omission. It involves affirmative acts taken by ACLS against Cedarbrook.
What's your response to the other side that a negligence action can't and won't lie when there is intentional action involved, and that this investigation that was launched by the agency was intentional and therefore negligence has no place?
So the Court of Appeals examined that issue in depth in Crump v. Diener, which involved an inspector for Diener who falsified certifications for septic permits. And that court relied heavily on this court's decision in Pleasant v. Johnson. Notwithstanding that those were intentionally falsified certifications, the court in Crump still found that it was negligence. The question and this is in reliance on Pleasant v. Johnson, the question is not whether the actions were intentional, but whether the injury was intentional. And the concept of negligence is eliminated only when the injury is intentional. Here, the plaintiffs have not alleged that there was an intentional injury, and in fact, counsel for ACLS has expressly disclaimed it. He said the regulators were just doing their job. In fact, if you look on page 447 of the record, this is from the Industrial Commission argument transcript. He says, and of course, we're not saying that the Department of Health and Human Services was intending to injure Cedarbrook, not at all, but rather that the employees were intending to do their jobs. That's exactly right. And they did their jobs negligently.
To go back a second to the conversation that you had with Justice Irvin, you're not saying that the tort that's being alleged here would open the scope to quasi-judicial actions like the Industrial Commission or the Utilities Commission. The way I understand your pleading is that it is focused on an agency that's exercising regulatory authority, not quasi-judicial action.
I think that's right, Your Honor. I don't think that there's a basis to apply the Tort Claims Act to quasi-judicial actions, and I also believe that that remedy is provided for through the appellate process that the legislature has established for those decisions.
So it seems to me factually, as you've indicated, that all of the allegations that led to the order that prevented any additional admissions, all those were withdrawn. Are there allegations in your complaint regarding gross negligence, or is this purely just negligence?
There are no allegations regarding gross negligence. We have only alleged negligence. And there have been numerous cases that recognize claims for negligence in the context of regulatory actions. Again, Watts and multiple claimants are both from this court's precedent. Gammons is an earlier case which involved negligent investigation of child abuse claims. And then there are numerous claims from the cases from the Court of Appeals. A line of cases that dealt with the inspection of properties and issuance of septic permits. Husketh v. Department of Corrections involved the negligent application of sentencing guidelines. It can apply, the Tort Claims Act can and has applied to innumerable contexts of negligent regulatory type actions that private persons do not have the authority to take.
Counsel, you mentioned multiple claimants, and I think you mentioned that in response to Justice Hudson's question. However, my reading of the opinion is somewhat troubling in the context that you're citing it, because Justice Timmons Goodson, writing for the court, recognized that there was a special relationship exception that applies in that case because between the state and inmates, this is the inmates fire case, because inmates have an inability to care for themselves. And I don't believe the case here is brought by the residents of this home. Instead, it is based on your client. So how do you reconcile that?
So the reason that was the discussion in multiple claimants is because that was still within the framework of the public duty doctrine. And so there's not a direct action by the state in that case against the inmates. There's an indirect effect, causality there. And the court had to find that special relationship in order to hold that the inmates still had a cause of action under the Tort Claims Act. Here, conversely, this is a direct relationship between ACLS and Cedarbrook. ACLS was taking direct action against Cedarbrook. And in its black letter law, that when you exercise a positive course of conduct against someone, you owe that person a duty of care. So it's a much more direct relationship. You don't have to get into that indirect, tenuous connection of whether there's a special relationship at all.
Thank you.
I'd like to ask about your view on the intersection between tort law and administrative law. And you talked about how an appeal through the administrative process was not adequate because it doesn't provide for the full compensation of all the damages suffered. But if the legislature had intended in these circumstances to provide that kind of relief, I guess I'm troubled with how we factor in General Statute Section 6-19.1, which is the provision that says that where an agency has acted without substantial justification in pressing its claims, you're entitled to your attorney's fees. And it would seem that the negligent enforcement action that you're suggesting lies here, or that occurred in this case, is precisely where an agency has acted without substantial justification. And the General Assembly has said, well, in those circumstances, if a regulated entity has to defend itself in the administrative process, they can recover their attorney's fees, but not other consequential damages.
And I would relate this, Your Honor, to an exhaustion of remedy type of question, where if there's not an adequate remedy provided for in the APA, a claimant can look elsewhere. Here, the General Assembly has also provided for the Tort Claims Act, which specifically applies to agencies, state agencies acting within the scope of their employment and authority. There is not an adequate remedy within OAH and under the APA to recover anything beyond attorney's fees. Here, this caused over $1 million in damages to Cedarbrook and Mr. Leonard. They cannot recover that. There is not an adequate remedy within OAH. Due process requires that a claimant have a meaningful hearing in a meaningful time and in a meaningful place. Now, we could look at this under a due process kind of analysis, but the General Assembly has already provided an avenue for relief. And there is no carve-out that says, well, since you can look under the APA, you can't also look to the Tort Claims Act. That language doesn't exist in the Tort Claims Act, and that's where you would expect to find it if the General Assembly intended to carve that off. The effect of precluding a claim under the Tort Claims Act would be to give rise to a due process quorum claim. And that is the wrong approach, where the General Assembly has already provided an avenue for relief.
So you're arguing then that the State Tort Claims Act is like a stopgap to fill in if the Administrative Procedure Act remedies don't fully financially compensate a regulated entity?
Certainly not as a general matter, because the State Tort Claims Act only applies to claims of negligence. And that is a question of fact, and the Industrial Commission has already determined that under our complaint, we have alleged a claim for negligence. So it doesn't mean that it applies to every time the agency gets it wrong. And given the summary nature of the licensure actions that were taken, this is an unusual circumstance, and that the damages were significant and they were severe and they were incurred before Cedarbrook ever had a remedy.
So help me understand where that line gets drawn then between, if it's not every time the agency gets it wrong, but sometimes there can be a tort. Where do we draw that line?
Well, I think the line is negligence. I think in most cases, this is not like, for instance, a permitting case, where if the agency denies a permit and they got it wrong, you still have a claim and you can challenge that denial and go through OAH into Superior Court and onto the Court of Appeals and here. And if at the end of the day, the permit is still denied and the agency's decision is affirmed, then you have an awfully tough time bringing a tort claim in that circumstance.
And that was actually something I was going to ask you. And I want to ask you first about your permit example. Again, let's say somebody applies for a permit, and if they got the permit, they would then be able to operate a business, earn income, and make a profit. They're denied the permit. They go through the administrative proceeding. They appeal. At the end of the appellate process, the holding is that the permit was wrongfully withheld. In that set of circumstances, if the only thing you've got is the remedy under the administrative process, there's no ability to go back and say, for example, if I'd gotten the permit a year earlier than I actually did, I would have been able to operate my business during that period of time and been able to make this amount of money. Is assuming that there was a negligent denial of the permit, is that a claim that can be brought under the Tort Claims Act?
Well, I think, again, that may look more like the kinds of quasi-judicial decisions that this court hasn't said fall within the scope of the Tort Claims Act. But I do think the agencies, as a general matter under the Tort Claims Act, owe a duty.
Secondly, let's say hypothetically that instead of settling, you had proceeded to trial before the Office of Administrative Hearings and lost, would that decision have res judicata effect in terms of your ability to bring a tort claim action like the one that you brought here?
Almost certainly, Your Honor. It would be difficult to allege negligence if we've lost in OAH.
If that's the case, then does your position in essence discourage the agency from entering into a settlement with a regulated entity?
I don't think so, Your Honor. This was an unusual circumstance. The allegations were extreme. I don't think the state wanted to be in front of OAH defending their decisions, such as trying to prevent the sexual activity of Cedarbrook's residents, which these were the kinds of decisions that they were imposing on us. Because according to ACLS, those residents could make informed decisions but weren't making good decisions. This was an extreme and unusual case, and I don't think that allowing the Tort Claims Act to proceed here discourages settlement in the future. I think it encourages ACLS to proceed more carefully in the future, which is the policy that the General Assembly has established. The General Assembly has said state agencies acting within the scope of their employment should proceed with reasonable care. That is the relief that they have provided, and that is the claim that Cedarbrook has brought here. It is the policy of this state that agencies exercising regulatory authority are held to a standard of reasonable care, because when they do so negligently, it can cause real harm, as it did to Cedarbrook. And the avenue for relief is the Tort Claims Act. I'm just about out of time. I'm happy to answer any other questions you may have. Thank you.
Rebuttal.
Thank you. I'd like to start by addressing the question of the summary suspension, which Cedarbrook's counsel mentioned multiple times. That is a remedy specifically provided in 131D 2.7. The title of it is Summary Suspension of License. And the General Assembly has given the authority to the department to summarily suspend a license whenever it finds substantial evidence of abuse, neglect, exploitation, or any condition which presents an imminent danger to the health and safety of any resident of the home. And I think that represents a common sense approach by the General Assembly to dealing with a situation where the department comes in and it's concerned about the safety of the people living in a facility, whether that's, here it's an adult care home. Vulnerable residents live in nursing homes, congregate care situations for foster children, and the General Assembly's priority in these situations is to ensure that people are protected.
Well,
And so
let's
that's
talk
why it
about
gave
that.
the,
Ensure people are protected. What happens if the whole process that's engaged in fails to discover the truth? In other words, you talked about, in answer to my question initially, the violations. Well, we don't know if there are any violations unless the evidence gathering process was properly done. And the allegation here is that the evidence gathering process was flawed right from the beginning, and that the agency failed to even engage in the explanations that were offered by Cedarbrook. If that, in fact, is true, how can there be a proper suspension or a proper action if the evidence of any violation was improperly?
and our position, Your Honor, is that in that situation, accepting the claim that none of these was merited or the investigation was entirely improper, that that's what the administrative remedy is for, including, as opposing counsel mentioned, the opportunity for a preliminary injunction to go quickly in front of the Office of Administrative Hearings and be able to show that whatever action was taken was unwarranted. And our position is that if you read the statutes governing the regulations of adult care homes and the remedies that they specifically provide, like for a summary suspension, filing a contested case, that the General Assembly's priority is clearly manifested. That first, in the case of a suspension, let's not admit any new residents until we make sure residents in this facility are safe. If that turns out to be unwarranted, the investigation was improper, file a contested case, challenge it, do a preliminary injunction using the procedures in the APA if needed. But the statute does not say, and the General Assembly has not authorized anything like the kind of remedy that the plaintiffs are seeking here. If the General Assembly has intended that kind of relief, it could have simply said, in the event that the suspension of admissions was improper, the facility shall have, recompense, that it shall be able to bring a claim, or it shall be able to recover lost revenue as a result of the people who weren't admitted. And the General Assembly simply didn't say that. And our
At what
position
point
is
is
that
there
it's
a
improper.
constitutional taking?
I'm not quite sure how to answer that question, Your Honor. We haven't briefed or analyzed it here. I don't think it would rise to this level. I think that this case, when you read the allegations, involves straightforward regulatory action according to the statutes that the General Assembly passed. And even assuming that plaintiff's allegations are true and that there were problems with the process here, the kinds of problems that they're talking about aren't things that would rise to the level of a regulatory taking. So for example, they claim that it was improper for the department to interview people with mental illness and get their reports about any conditions that they were experiencing in Cedarbrook because they weren't reliable narrators. To the extent that that's a valid theory, I don't think it rises to the level of a constitutional violation. It seems much more like the kind of standard administrative law question that the Office of Administrative Hearings should be dealing with and looking at what's the proper process under the rules and regulations to conduct this investigation, what information can the department rely on, and so on. So that's the central problem with this claim, is that it is attempting to turn a regulatory inspection into a tort claim, resulting in a new action in a new forum on the exact same issues. And we submit that that's improper and that the case should be dismissed. And
Thank you, counsel. Thank you, both counsel. Mr. Clerk?
All right. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 11 a.m. God save the state and this honorable court. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Welcome everyone to the historic 1767 Chowan County Courthouse. Our state constitution provides that the Supreme Court of North Carolina is to hear our cases in Raleigh or other places as designated by the Supreme Court. I mean, not by the Supreme Court, by the legislature. In 2004, the legislature, in response to the renovation and restoration of this courthouse, passed legislation saying that we could hold court in Edenton. Last time we were here was 5 years ago. We're delighted to be back in Edenton, and we so appreciate the folks here in Edenton for their incredible hospitality, so welcoming to all of us, and we appreciate that. I noticed some high school students in our group. Welcome. We're glad to have y'all with us this morning as well. The case we have next is Harper et al. Versus Hall et al., and we will hear from the appellant.
Good morning, Your Honors. I'm Elizabeth Theodore on behalf of the Harper plaintiffs. I'm addressing 3 issues today: the legislative defendant's congressional appeal, their motion to dismiss that appeal, and the plaintiff's appeal of the remedial Senate map. And I'd like to reserve 6 minutes for rebuttal. The court should not dismiss legislative defendant's congressional appeal because doing so would reward their gamesmanship and prejudice the plaintiffs. The legislative defendants are in the United States Supreme Court right now in this case, asking the court to decide what they say are open questions of North Carolina state law, of state statutes governing judicial review of congressional maps, but this court should be the one to decide those questions on the merits.
Let me ask you about gamesmanship. What do you mean by gamesmanship?
So, for example, the legislative defendants in their cert petition and in their cert reply specifically cited the trial court's remedial decision as one of the decisions justifying the grant of cert in the United States Supreme Court. They specifically said in their cert petition, in their reply, that the imposition by fiat of a remedial map by state courts supported cert. And so for them to turn around, having obtained cert on the basis of that challenge and attempt to dismiss the appeal constitutes gamesmanship, as does...
How is that so when their request to the U.S. Supreme Court deals with a federal constitutional issue, not a state constitutional issue? And that federal constitutional issue has arisen regardless of what we decide with regard to the congressional districts at this point.
Well, Your Honor, it doesn't arise regardless of what you decide for 2 reasons. First of all, they are pressing in the Supreme Court an elections clause, a federal elections clause challenge to the imposition of a remedial map independently from the court's Harper 1 decision on liability. And so for them to try to leapfrog over this court and dismiss their appeal in this court while keeping...
How is it leapfrogging over this court when it's a federal constitutional challenge, whereas this court is focused on state constitutional challenges?
Well, the normal rule in the United States Supreme Court is that you have to press all of your federal arguments in the court below if you want to preserve those arguments to the United States Supreme Court.
Well, apparently they believe that's already been done. Hence they granted cert. And it seems to me your argument is better placed at the Supreme Court of the United States. Why wouldn't you make that argument there?
Well, 2 reasons, Your Honor. First of all, at the time the Supreme Court granted cert, the legislative defendants had not moved to dismiss this appeal. And second, deciding whether an argument is preserved under North Carolina law, which is the second thing we want this court to address, is a matter of North Carolina law. And let me just point you to what the legislative defendants said in their cert reply to the United States Supreme Court about this very issue. We said to the Supreme Court, you should deny cert because The legislative defendants at the liability phase had never raised an elections clause argument in the trial court. And the legislative defendants said, if the North Carolina Supreme Court thought that that argument was waived as a matter of North Carolina law, they would have said so. You can look in their cert reply, that's what they said. It's for the North Carolina Supreme Court to say whether an argument has been preserved as a matter of North Carolina law.
Didn't the majority opinion address that argument?
The majority opinion said that it hadn't been raised below, but they were addressing it anyway. And the legislative defendants pointed to that and said because the majority had not said that it was waived, it was preserved for the United States Supreme Court. And so here, where the legislative defendants have expressly and intentionally forfeited their elections clause argument as to the remedial plan in their brief in this court, it's really important for this court to say that that is a waiver as a matter of North Carolina law. And so that's the second thing we're asking the court to say. The first thing we're asking the court to say is to hold that section 267.1 and section 120-2.3 and section 120-2.4 specifically authorize state court judicial review of congressional districting plans for compliance with the North Carolina Constitution, including adoption of remedial maps. And that's important because the legislative defendants are asking the Supreme Court to reverse this court's merits determination in Harper 1 and the trial court's imposition of the remedial map on the erroneous theory that these statutes don't apply to state constitutional challenges at all. And they're telling the Supreme Court that these statutes are, quote, best read as merely laying out the procedures that govern a federal constitutional challenge brought in state court. That's what they are currently saying to the United States Supreme Court. That's why they want to dismiss this appeal, because they want to be able to press that completely wrong and atextual argument about North Carolina state law in the United States Supreme Court. And it is very, very clear, both under this court's jurisprudence and under the United States Supreme Court's jurisprudence, that interpreting state statutes is a matter for the state court. And the reason this is important is because if these state statutes, as they do, specifically authorize judicial review by the North Carolina State Court under the Constitution of Congressional Redistricting Plans, it doesn't matter whether the legislative defendant's federal elections clause argument is right, because the legislature will have authorized the review at issue.
What would be the consequence if we did dismiss the appeal?
If the court dismisses the appeal, I think the court should say that as a matter of North Carolina law, all of the arguments with respect to the remedial map are waived. The elections clause argument is waived as a matter of North Carolina law. And as we've explained, we've explained some other things in our brief that I would direct you to that for the best articulation of the sort of collateral estoppel and res judicata consequences.
Would you foresee any consequence in the Supreme Court of the United States?
Yeah, we would argue that, and I think, look, of course, the federal consequences are for the United States Supreme Court to decide,
Right.
but the state consequences and what the dismissal means for state law is absolutely for this court to decide. And if this court doesn't decide those questions and it doesn't say what we've suggested, the legislative defendants will rely on that silence, as they did at the search stage, to say that there has been no waiver as a matter of North Carolina law. And so, look, as we've said in our brief, we think the best thing to do is to just decide the congressional appeal. Rule 37 makes clear that the court does not have to dismiss at this stage. This court's precedents and other precedents make clear that it's appropriate to consider gamesmanship and prejudice when deciding whether to dismiss. The appeal is now fully briefed, so we think the best thing to do would be to affirm the trial court's decision imposing an interim map and hold specifically that these state statutes authorize judicial review under the state constitution, and that the elections clause argument is now waived because it's not in the opening brief. And unless the court has questions about the substance of the trial court's on the proposed remedial map, I'd like to turn to our appeal of the Senate decision. So the standard in Harper for constitutionality is whether voters of all political parties have substantially equal opportunity to translate votes into seats. And that means the court said that voters are entitled to have substantially the same opportunity to elect a supermajority or a majority representatives as the voters of the opposing party would be afforded if they comprised the same percentage of the statewide vote share in that same election. And so the trial court committed legal error with respect to the Senate map because it did not actually address that governing standard. Overwhelming evidence, including the reports of all three neutral advisors, showed that the remedial Senate plan failed that standard and significantly favored Republicans. And I'd say the clearest evidence of the failure to satisfy that standard is in the graphic at page 24.
Well, at a more fundamental level, is your argument that the trial court in the remedial orders decision lacked sufficient support, or are you saying something else?
We're saying both. We're saying that this trial court applied the wrong legal standard. It never actually addressed or made any factual findings about the actual legal standard. And then we're also saying that with respect to the standard, the court did apply the mean, median gap, and efficiency gap standard. It made factual errors. It was not supported by competent evidence.
I mean, it is, of course, up to the trial court to decide within limits what factual decisions to make under our standard of review, isn't it?
Well, what we're saying is that the trial court, the trial court had to address the ultimate legal test that this court set out in Harper 1, and it never did that, and that is a legal error. It didn't make any factual findings that go to the ultimate legal test this court set out. Instead, what the trial court did was it said that the map was constitutional because it satisfied or purportedly satisfied an efficiency gap threshold of 7% and a mean median threshold of 1%. But this court specifically said in the Harper 1 opinion that satisfying those metrics does not insulate a plan. It said we are, quote, not identifying precise mathematical thresholds which conclusively demonstrate or disprove the existence of an unconstitutional partisan gerrymander. And that's exactly what the trial court did. It said that it was going to ignore all the other evidence, including the fact that every single neutral special advisor to the masters concluded that this plan had significant partisan bias. And it said that it was going to rely on those two thresholds to conclusively disprove the existence of a partisan gerrymander.
So why isn't that analysis of the evidence from the experts within the discretion and the role of the trial court?
Well, the trial court has to actually address the relevant legal standard. And the relevant legal standard is whether voters have substantially the same opportunity to elect a supermajority or majority of representatives as the voters of the opposing party would be afforded if they had the same percentage of the statewide vote share in the same election. And the trial court just didn't address that standard, and that's a legal error. That's not within the discretion of the trial court. And I would just point you to the graphic at page 24 of the Harper opening brief, and this is an analysis by Dr. Mattingly and Hirschlag that goes directly to the metric the court announced in Harper 1. It is measuring how many seats each party would get at the same vote share across the 16 most recent statewide elections. And you can visually see on page 24 the enormous disparity. There's on average a 4-seat advantage for Republicans at the same vote share. And even Dr. Barber, who was the legislative defendants expert, his analysis showed that the Senate map failed this court standard. His analysis showed, and this is the graphic on page 27 of our brief, that when the Republicans get 55% of the vote in the Senate map, they get 33 seats, which is a supermajority. And when the Democrats get 55% of the vote, they only get 28 seats.
Is it your position that the trial court was required to address and either accept or explain why it was not accepting the testimony of each of the experts?
Our position is that the trial court was required to assess the evidence that went to the standard this court identified, and it didn't do that. But also, Your Honor, I mean, with respect to the mathematical metrics that the trial court looked at, it committed very clear factual error. So the court, the trial court said that if you satisfy the 1% mean median and the 7% efficiency gap, then you're constitutional. And we disagree with that, but the fact of the matter is the trial court was simply wrong about the 1% mean median standard. So the trial court adopting the special master report said that a majority of advisors and experts found a mean median gap of less than 1%. And I mean, it's not just that that's not supported by competent evidence, it's just wrong. The opposite is true. So 2 of the 4 special master advisors found a mean median gap of more than 1%, and 2 of the 3 experts found a mean median gap of more than 1%. So a majority of the experts and advisors found that the map failed even the standard that the trial court identified. And I'll note that the 2 special master advisors who found a mean median gap of less than 1%, were using a single election composite rather than a bunch of representative elections, which is what this court said was the relevant test. And
Counselor, excuse me, you used the word majority
Yeah.
when you were comparing. That to me suggests that you're asking us to reweigh the evidence. Could you please address your point in that regard?
I'm not asking you to reweigh the evidence. The trial court said that its determination was correct because a majority found that the mean median gap was less than 1%. In fact, as is undisputed, a majority of the advisors and experts found that it was more than 1%. So it's not a matter of reweighing. It's just a matter of the fact that the relevant metric the trial court identified pointed in the opposite direction. And that's very clearly not supported by competent
And a
evidence.
follow-up then, with respect to the special masters, was that language found there as well, or just in the order?
The majority language was in the special master's report, but the trial court adopted that report.
And to that end, there should be a presumption of legislative appropriate behavior. By simply adopting the legislative report in whole, the special master's report in whole, does that suggest perhaps that presumption was or was not honored?
I'm not sure it suggests, I don't think it suggests that either way. I mean, for the reasons in our brief, we don't think a presumption applies in the remedial context. And that's what multiple courts have held. If I could reserve the remainder of time for rebuttal, please. Thank you.
Good morning, Your Honors, and may it please the Court. I'm Hillary Klein, a member of the Chatham-Orange County Bar, appearing on behalf of Common Cause, and I'd like to reserve 3 minutes for rebuttal. I'd like to address 2 matters today. First, Common Cause's equal protections challenge to the state legislative maps and the harms still present in those plans. And second, the trial court's failure to reject the House map as an unconstitutional partisan gerrymandering. To my first points, legislatures violated North Carolina's Equal Protections Clause because they intentionally destroyed 2 functioning crossover districts in the areas of Senate District 4 and House District 10 that under the benchmark plan performed for Black voters. Legislatures knew because their own experts told them that the districts they had drawn in 2021 for these areas would deny Black voters the chance of electing a candidate of their choice. Their own experts told them, and that is not in dispute. But when legislatures went back to draft remedial maps, where they had statewide discretion to bring those maps into partisan compliance, they purposefully chose to redraw other areas of the state while ensuring the destruction of functioning crossover districts in eastern North Carolina. Legislatures destroyed these crossover districts, even though preserving them would have helped bring the map into partisan compliance.
Let me ask you a quick question. Do you have any specific authority for the proposition that it's a violation of the Constitution to dismantle crossover districts?
Yes, Your Honor. The Supreme Court, the federal Supreme Court, actually made that observation in the Strickland case, specifically saying that any intentional destruction of crossover districts would bring serious equal protections, 14th and 15th Amendment. And as this court is aware, the state equal protections clause is actually even more broadly interpreted than the federal clause. When they started...
This may be a premature question, Ms. Klein. If it is, tell me. But assuming for purposes of discussion, I'm bad to do that, that we were to accept your argument, what is the scope of the remedy that you are requesting solely with respect to the destruction of crossover districts issue? I was a little unclear after reading the briefs. I'm sure, please enlighten me.
Common Cause has proposed and did propose in the remedial stage 2 crossover districts, 2 configurations that would preserve the crossover districts in these areas. For the house that is within the same cluster, so it's not that it will cause a ripple effect, it's very minimal, the same cluster. These are compact districts. They were drawn without race predominating. They are crossover districts drawn within that house cluster. And for the
Are you
Senate,
suggesting that we specifically, this court adopt those districts, or that we remand to the trial court for them to apply a remedy that might include adopting those districts?
we submit there is enough evidence that's undisputed from the remedial stage that this court absolutely can order those remedial districts. The Fourth Circuit did something similar in the McGee case in the Fourth Circuit. But at the very least, it would require remand if the court, even if the court disagreed.
But to make sure I understand your answer to the question I asked a second ago, the only remedy that you are requesting is either a remand or an order that would require adopting the 2 districts that have been identified in your briefs, plus adjustments to the surrounding districts?
Yes, Your Honor, just for the equal protections
Right.
violation,
Well,
it would
and
just
I
be
mean, I
the,
was trying to isolate the remedy that you were seeking with respect to your destruction of crossover district claim.
yes, Your Honor.
So basically, all you're asking is that the 2 districts that you've identified be approved, and then any necessary adjustments to surrounding districts be made. That's it.
Yes, but I would note that for the House, again, it's isolated to that cluster. And for the Senate, it only requires combining one other cluster with one county split in Wayne County. So these are very limited proposed remedies to preserve these crossover districts. And that's further consistent with what this court did in the Stevenson case, where a similar equal protections concern came up when the court was considering what the appropriate remedy would be. And there the court said that all state constitutional provisions have to be harmonized. And that includes the whole county provision with the equal protections clause. These have to be harmonized, and Common Cause submits that its proposed remedial districts are the best harmonization of all of those.
And I guess I want to follow up on the question that Justice Hudson asked you. I heard you, she asked you what, are you asking us to remand it or propose or order the adoption of these districts as you have proposed them? And your answer, at least as I heard it, was you can order it or you can remand it. Do you have a position as to what we should, if I was to ask you directly, what are you asking us to do? What is your answer?
We are asking the court to order that Common Cause's proposed crossover districts be ordered on
Why
remand.
should we do that in lieu of remanding it given the constitutional structure of the state?
Because there is enough evidence that is not in dispute from the remedial stage to substantiate that these proposed remedial districts are the best way to harmonize all of the various state constitutional requirements. And the court and courts have done similar orders on remediation. I'd like to briefly address the
Let
second
me push
point.
on that just for a second. When you say it's the best way, that sort of implies that there might be other ways that would be acceptable. And if that's the case, why isn't that better handled by the trial court, subject to review by this court if necessary?
There is enough evidence from the remedial stage to show that these remedial districts best harmonize all of the state constitutional provisions. There probably are other configurations that are possible, but quite frankly, the legislature already had a chance to do this in the trial court, failed to even consider these plans when it was confronted with these. And the best remedy in that situation is for this court to order equal protections, a specific equal protections remedy to, again, remedy the harm to the voters in Eastern North Carolina who have been purposely targeted. I'd like to just briefly address, if I may.
In response to Justice Hudson's question about what case was supportive of your position with crossover districts, you cited Strickland. Strickland, however, talked about minority districts, and it said that there's no requirement of crossover districts. So how does that support your position?
Because this is a state, Strickland was considering VRA-related claims, federal claims. This is a state equal protections challenge, and this is the remedy to remedy a state equal protections violation of purposeful discrimination against voters in these areas.
But Strickland doesn't address that at all. Strickland is looking at Voters' Rights Act and requirements under the Voters' Rights Act.
Yes, Your Honor, and it observed that the intentional destruction of functioning crossover districts would absolutely raise equal protections 14th and 15th Amendment problems. So even though it wasn't squarely on point, the court actually went out of its way to specify that that would be equal protections violations, and that's exactly what we're contending here. I'd just like to briefly address the unconstitutionality of the House map. The court committed the same legal errors that my colleague has discussed, but importantly, the court erred as well in determining whether political geography necessitated the partisan skew in the House map. All of the competent evidence shows that the House map denies substantially equal voting power. This is not necessitated by political geography of North Carolina. Our expert evaluated that and found as much. We asked the court to reverse the remedial order as to the state legislative maps. I'll reserve any remaining time for rebuttal. Thank you.
Thank you, counsel. I'll observe that you have just over 5 minutes between the two of you for your rebuttal, so y'all have to adjust your time accordingly. We'll hear from the other appellant and appellee.
Morning, Your Honor. May it please the court, Phil Strack, for the legislative defendants. I'd like to reserve 3 minutes for rebuttal. The era of judicial redistricting began this year, and based on the remedial process at issue in this appeal, it's already broken. This remedial case started with 2 sets of plans drawn by the legislature, legislative plans and congressional plans. These plans were submitted to the trial court for approval. All of these plans were drawn using the exact same metrics, the mean, median, and the efficiency gap, which was identified by this court. All of these plans were drawn using universal mapping software Maptitude to calculate the metrics.
Mr. Strack, I'm sorry to interrupt you, but before you get too far into it, do you want to say anything to address the motion to dismiss the congressional?
Well, Your Honor, we'll stand on our motion. We think that that appeal should be dismissed, and we'll be glad to stand on our papers.
Okay, thank you.
All of those plans use Maptitude to calculate the metrics, and all of those plans were drawn using nonpartisan staff to use Maptitude to calculate the metrics, all to make sure they comply with this court's order.
Has anybody alleged that the Maptitude map itself was an improper tool to be relied on by the General Assembly?
No one has. Not the trial court, not the plaintiffs, no one has. Maptitude is universally used as an objective source to make those measurements. And that's what it was used. And frankly, that's why it was used, to ensure there'd be no question about the objectivity of the actual metrics.
If you use, instead of Maptitude, you use Bob's redistricting app, as apparently at least maybe the trial court or the special masters may have used, will that impact the outcome of any analysis?
It can. It obviously did. It's Dave's redistricting app, by the way, and it did, because obviously when the trial court hired its special masters who hired their assistants, they literally all came up with different calculations, results for these metrics, because they all use different ways. I mean, you had, for the congressional map, for instance, you had Dr. Groffman for mean median. He had 0.66, Dr. Jarvis 0.9. Dr. McGee said it might be 1.1, it might be 1.6. Dr. Wang said it might be 1.2, it might be 0.7. They literally all come up with different numbers for what ostensibly has been represented to be a simple math problem.
Well, I'm trying to figure out the simple math part. So Maptitude versus, Dave's redistricting app. But then also, I guess it depends on, you pick the statewide races you want to plug into that. you're going to get different outcomes. Is that a correct statement?
That is the reason for the different calculations. Dr. Jarvis put it like this. He said different.
Mr. Strack, I was going to ask you this. and
Sorry.
Please finish answering the Chief Justice's question. The only variable then is which elections are used to conduct the measurement?
No, Your Honor. So
I thought there was a second one, and I wanted to make sure that
that's going to be a question. So the reason for the different results is because they not only use different election data, and what Dr. Jarvis said was different plans perform differently under different elections, and that is invariably true. And so you got to pick what elections, but also these measurements, these metrics themselves have different ways of calculating them, whether you do them individually. There are literally thousands of ways, permutations, commutations of ways to just for these two measures. That's not even counting all the other alleged measures of partisan fairness that this court even mentioned in its analysis. And respectfully, Your Honors, what we would submit is this is no way to conduct constitutional analysis. This simply isn't the way it should be done.
Is it a policy choice to determine whether you're going to use Maptitude or Dave's or some other redistricting? And is it a policy choice to determine we choose these 12 statewide elections relied on by these experts versus 13 versus 11 versus different 12? Are those all policy choices?
Yes.
And if so, who should make them?
Yes, Your Honor. We believe those are all policy choices that the legislature should make within the contours of what this court's order was. The legislature did exactly that by choosing mean, median, efficiency gap, because those are the two measures that this court gave actually specific guidance about the threshold.
And let me, I don't claim to be any more of a math scholar than the Chief Justice apparently does, but it seems to me that the argument that you have made in your brief is that, and my ultimate question is, am I reading your brief correctly? Is that once the General Assembly determines how a particular calculation under one of these approaches should be made, that calculation is somehow binding? Is that the argument, or are you making, am I misunderstanding your argument?
That's part of the argument.
Okay.
What we're contending and what we've said in the brief is that the measure that the General Assembly chooses and the way it chooses to calculate that measure should be given deference.
All right, and deference means, just because we seem to be engaging lots of semantics lots of times, in your view, deference means what?
It should be accepted unless it's obviously wrong.
Is the trial court given, in a remedial context, given any discretion to determine whether a particular calculation was either inappropriate or erroneously performed in the sense that some other version of the variable ought to have been used rather than the ones that the General Assembly did? I'm sorry if that's a badly worded question. I hope you understand where
I'll try to answer it this way, Your Honor. If there had been evidence that Maptitude calculates these metrics wrong, then that's obviously evidence that the trial court could have taken into consideration about whether to accept those measurements. But the General Assembly used Maptitude. It objectively used nonpartisan staff to make the calculations on Maptitude, so there would be no question, so that none of the questions that have been raised in this appeal would even be an issue. And as to all those metrics that the General Assembly measured, both the House and the Senate and the congressional plan all met the 1.0 and the 7.0 metrics that this court identified. Yet,
to what extent then are you arguing before us that ultimately whether either of these two metrics is established, presumably in most instances, would be a decision of fact for the trial court, I would assume? Is that understanding wrong?
within the deference that the trial court owes the General Assembly as a matter of this court's jurisprudence.
Right. And so does a trial court have the authority, in your view, to look at these calculations and determine that in a particular set of circumstances, in the trial court's opinion, these results aren't an accurate measure of what the legal standard sought to achieve.
I don't, if you're using mean, median, efficiency gap, and using magnitude, I don't see how the trial court could come to any other conclusion other than those are valid measures.
I mean, and I'm talking about as an analytical matter, not necessarily as a matter of results. If the trial court concludes that these two measures are appropriate as a general proposition, do they then have the authority to examine the manner in which those approaches ought to be applied?
Our argument is they have to defer to the legislature's choice of how they're applied unless the legislature's choice is obviously wrong.
So what's your authority for the deference, giving deference to the legislature in this process of a remedial redrawing of maps that have been declared unconstitutional?
Well, the best authority that I can think of is the Stevenson line of cases. The Stevenson cases made clear, every case that came up to this court, that the presumption of constitutionality applied. Now, this court in Harper 1 has actually added a new layer of a presumption of constitutionality, where this court said effectively that if you're within the metrics, the 1% and the 7, then there's a presumption of constitutionality again.
There may be a presumption of constitutionality.
Well, maybe, but it's not much of a presumption if you don't know it's going to be a presumption going into it. See, the General Assembly really has to put pencil to paper on these things. They have to have actual metrics. They have to have standards. They have to know how to draw it in advance to meet this court's orders. And if what the General Assembly has to do is pick randomly out of a mishmash of elections and metrics and just shoot in the dark, it can't draw a plan that way, because what happens then is it becomes the court's decision as to what map to
If the
use.
trial court is supposed to oversee the redrawing by the legislature, how can they do that without reviewing the calculations and the methods that are used by the General Assembly in producing the product that they submit to the court for review?
They can and should review the metrics, but they should defer to what the General Assembly used unless what the General Assembly did was obviously and clearly wrong. And that is manifestly not the case here, in our opinion. Here, the exact same measures were used in the exact same way for every single map. And what happened? The trial court accepted Senate and House map, rejected the congressional map. Well, that happened because you had this mishmash of calculations that the special master assistants came up with. And they rejected the congressional plan and accepted the others, even though on all of the measures, mean, median, efficiency gap, all of the assistants and the party's experts, a majority of them, found that the mean, median, or efficiency gap was within the presumptive court had set. So what was the difference between the Senate and House maps and the congressional map? Well, we don't know. Why? Because the trial court didn't tell us. It said it was relying on the special masters and the assistants, but those reports show that the congressional plan was in a good position as a Senate plan. And then if you're thinking about the congressional plan, think about Dr. Jarvis's conclusions. He's the only one who ran with this ensemble concept. And he was, that as a result, he was able to actually look at political geography. As he said, the individual metrics provide some insight as to gerrymandering, but that depends heavily on the political geography of the state. So it is important to interpret those scores in the context of ensembles. He did that. Nobody else did. What did Dr. Jarvis conclude about the congressional map? It was not a gerrymander. Not a gerrymander. So the only expert to consider that plan in the context of political geography concluded it was not a gerrymander. What he did conclude was that the LCV map was an outlier in favor of Democrats. But the legislative defendants plan was fine. And that was as to all the metrics: mean, median, partisan bias, efficiency gap, declination. So how do we reconcile? If you're the legislature and you're looking at this and you drew these plans using these measures, how do you reconcile the trial courts approving the legislative plans but disapproving the congressional plan? And respectfully, we would submit it can't be reconciled. In Harper 1, this court noted that in Baker versus Carr, the U.S. Supreme Court entered the political thicket. Based on the remedial process at issue in this case, the courts in North Carolina have now moved past the political thicket and have entered the political wilderness.
So now are you asking us to reverse what we said in Harper versus Hall, where we made clear that the overall arching question is whether or not all voters have the same opportunity to translate their votes into seats, and that these measures are one way to address that, but that the court should be looking at the totality of the circumstances?
Right, Your Honor. What we would contend is what this remedial process proved is that's not a judicially manageable standard.
So you're asking us to reverse what we held in that case?
I'm just saying that this remedial process, which is an issue in this particular appeal, demonstrates that what this court gave the trial court is not judicially manageable. What it did is it gave the trial court carte blanche to pick the maps that it wanted to pick based on whatever reason it had, but it wasn't based on the metrics, because the General Assembly's metrics were all within this court's guidelines and were all the same for all the maps.
Well, let me ask you about another judicially established standard under Stevenson, the question of districts needing to be geographically compact. And in that circumstance, Maptitude similarly has, is it 12 different measures of compactness? And our courts have never said, as the General Assembly can pick one or two, and given a bright line cutoff for Maptitude has to produce a measure that meets this standard on the compactness measures. Instead, the court in Stevenson looked at some of the districts and said that district is not geographically compact and required the legislature to redraw them.
Yeah, I don't, in that case, I don't recall that the legislature picked a particular compactness score and said, hey, the court, you should defer this score.
Right, but I guess my point is, overall, big picture, we use that method to determine that under the state constitution, legislative districts are sufficiently geographically compact. How is that different than in this situation? We're using a variety of measures, but say to the trial court, ultimately, you have to make the determination of whether or not these plans are fair to all voters across the state.
Well, in the Stevenson 2 case, all this court was doing was upholding the findings made by the trial court. I don't read Stevenson 2 as making any affirmative statements about whether Maptitude should or not be used, or what measures of compactness are correct or not. That wasn't an issue, and as far as I know, it's never come before this court again. Perhaps, Your Honor, if a map was struck down specifically because the General Assembly chose a compactness measure that the court didn't like, that's a case for a future day. But I don't see how that helps the plaintiffs or the trial court in this situation, where objectively, verifiably objective numbers were used out of a software that no one questioned, and yet the trial court came to manifestly different conclusions on maps that use the same metrics.
So are you saying, in essence, that by giving deference to the General Assembly's methods and calculations, that the trial court, in essence, is not allowed to weigh that evidence, that that they just have to take it at face value and adopt it if they give deference? Or is that something like the rest of the evidence that the trial court weighs and decides what to believe and what not to believe and makes findings of fact and conclusions of law?
But to the point, to the question that Chief Justice asked earlier, in this area, unlike any other, which metrics you use, which elections you use, how you calculate them are manifestly policy decisions. So the court should defer the General Assembly when it makes those policy decisions unless they make obviously wrong decisions. No evidence points to the fact that the General Assembly's use of mean median, the way it was calculated under Maptitude, how it used the staff to do that, no evidence has called that into question.
You used the word, go ahead. You used the expression obviously wrong several times. A clear error is a standard I recognize. I'm not sure about obviously wrong. I don't know that I've ever seen a case that used that expression. Mr. Carr, what do you mean by what is obvious? What's something that's obviously wrong and something that's not obviously wrong?
It's like anything. When the court applies a presumption, it takes a lot to overcome that presumption. Otherwise, it wouldn't be a presumption. So in this particular case, for instance, if there had been evidence that had come forward that said Maptitude calculates mean median wrong. And it's been established that Maptitude calculates mean median incorrectly. And the General Assembly ignored that, went ahead. Then the trial court could say, well, the use of the Maptitude, we're not going to defer to that because it was clearly wrong. And that's what I mean. Maybe I'm using some colloquialisms here, but that's what I mean.
I've been known to do that myself, so that's.
Well, so I wanted to ask you about the statement you were making earlier about the fact that in deciding how to evaluate whether or not a map is a partisan gerrymander and which election returns to use for the various political science ways of testing that it's a policy decision of the General Assembly which elections to use for that analysis. And I'm curious how that squares with the long line of cases in the Section 2 of the Voting Rights Act jurisprudence, where the task is to evaluate racially polarized voting, and courts have been very involved in deciding whether or not an expert chose the right elections to evaluate racially polarized voting. And in fact, in a case in the Fourth Circuit out of Alamance County, the court said that the experts had only analyzed races involving Black versus white candidates, and that they needed, as a matter of law, to also analyze cases elections involving white versus white candidates. So the court there is establishing what types of elections need to be looked at in order to meet the legal standard, ultimately approving racially polarized voting. Why isn't the same true here?
Well, Your Honor, for one thing, cases involving racial discrimination are based and premised upon specific language in a statute. They are not pulled out of whole cloth out of provisions that say nothing about redistricting. And so the language in the text of the statute by its nature constrains the court and itself provides some limitation on how the court does that. And then obviously once the Congress, in the case of the VRA, has given the courts the specific authority to enforce a particular standard that it has set out in actual text, well, of course, then the courts have the ability, the duty to grapple with that and to over time figure out what are the best ways to measure that which the legislature itself has given the court authority to enforce. That is not the case here. There is no fair districts amendment to the North Carolina Constitution. There is no text constraining this court's exercise of the judicial power. And so in this case, uniquely, when the court chooses what elections to use, how to calculate the metrics, it is making policy decisions about how much partisanship is too much. It's not saying you can't use partisanship at all, like is the case in some states. It's saying, well, you can use some partisanship. Well, there's no text, there's nothing for the legislature or this court to lean into to decide what does that actually mean. In that situation, these are inherently policy decisions for courts to be deciding the very fundamental issues at issue when you draw a map using some level of partisanship. And the danger here, in our opinion, is that when the court opens it up, the plaintiffs are asking, the legislature used the mean, median, and efficiency gap. The trial court went with that, even though it somehow managed to come to different conclusions on different maps using the same metrics. But the plaintiffs here want to open this up to this, what they call this holistic analysis. And what that would simply do is it would transform redistricting into a game of gotcha by litigants in the courts. Because there are so many ways to calculate these metrics, this approach would intentionally create ambiguity so that if the political result isn't obtained by a particular litigant of whatever persuasion, then they can come in and ask the court to second guess it.
And I guess one of the concerns I've got, and I think I referred to you as Mr. Farr a second ago, which I apologize for, I was looking at him.
Yeah.
Mr. Track, we've got on the one hand concerns expressed that a General Assembly, by virtue of the fact that these calculations are affected by various variables, that the General Assembly, I mean, I don't never like this word, but I'm going to use it, can quote unquote game the system by a selective use of particular elections. You've got that concern on the one hand, and you've got a concern that a plaintiff might try to game the system on the other in the way that you just described. Why is it not permissible for a trial court to take those risks into consideration, treat this as ultimately a factual determination of the type that a trial court typically makes, and then have its decision reviewed for sufficiency of the evidence, so that the question before us in this instance with respect to both the congressional maps and the Senate map be, in essence, was the trial court's decision supported by the evidence that the trial court elected to deem credible?
Right, Your Honor, the two answers to that. The problem with that is that if essentially, in our opinion, eviscerates the presumption and the deference that the legislatures owe. Here, for instance, there was no evidence that the way the General Assembly calculated these metrics was gamed in any way.
Let me point you to paragraphs 14 and 15 and follow up to that question with regard to the trial court's order. It specifically talked about MAPTitude. It specifically talked about the 12 elections. Two questions arise from that. One is, where did these 12 elections come from? They were approved, but where did they come from? And secondly, in paragraph 16, it says the court finds the General Assembly's use of partisan data in this matter comported with the Supreme Court remedial order. So my question, as you look at that, is this not a finding of the fact by the trial court that MAPTitude and these 12 elections were a proper approach?
Yes, Your Honor, we believe it is. We believe that the trial court agreed with the way that the General Assembly calculated these, and then inexplicably chose one set as applies to a map versus another that were exact same for another map. The General Assembly, engaging in this process, erred on the side of caution in every respect. And we believe the trial court's conclusions reflect the fact that they erred on the side of caution. They were trying to find a manageable way to comply with the order and actually draw maps that could actually get votes in a legislative body. And that's a very difficult task. And they did that. And the trial court should have deferred to those judgments that it made, which it did in part, but then inexplicably didn't apply that to the congressional map. Why, we don't know, because the trial court didn't explain why it was rejecting one map over the other. And Justice Herman, to your point, this court in the past, in the context of redistricting, has adopted bright line rules. In the Pender County v. Bartlett case, the court adopted a bright line rule. And what the court said was that they were saying that the General Assembly deserves bright line rules in order for the redistricting to remain a legislative task and not a judicial task. That's what the court said. It also said that the General Assembly needed to have a safe harbor when complying with this court's directives. And it said that redistricting should be a legislative responsibility. And it said, we do not believe the political process is enhanced if the power of the courts is consistently invoked to second guess the General Assembly's redistricting decisions. So this court has already spoken on this issue. This holistic approach is not only not manageable, it not only invites the usurping of the redistricting function to the courts from the legislature, it's been specifically rejected by this court in the not so distant past.
You're into your rebuttal time, Mr. Trapp.
Okay. Thank you, Your Honor. No other questions. I'll reserve the remainder of my time for rebuttal.
Thank you.
Your Honors, the legislative defendants have made their position clear. They're asking the court to overrule Harper 1 and replace the standard from Harper 1 with a efficiency gap and mean median standard where the General Assembly gets to cherry pick which elections it uses and where you ignore all other evidence. And that's what they just said. That's what the trial court did with respect to the Senate map. It discarded the Harper 1 standard, and you heard no argument from the legislative defendants that the Senate or the congressional map actually satisfies the standard that this court articulated in Harper 1. They conceded the trial court didn't apply that standard. In fact, they claimed that it was impossible to apply, which is not true. This doesn't turn making maps into a game of gotcha. It's actually not that hard to pass a map that's fair. It's obvious that these maps weren't. They passed on, party line votes. So the problem isn't that the General Assembly can't, not partisan gerrymander. It can. The problem is that its remedial maps, both the congressional and the Senate maps, were dramatically skewed to favor Republicans, as all of the neutral advisors concluded. Exactly the same analysis that led the court to strike down all three 2021 maps means that the court should strike down the congressional and the Senate remedial maps. The chances of picking these maps without intent is vanishingly small. That's what the evidence in the undisputed evidence below showed. And I'd say that the discussion here illustrates why the court should stick to Harper 1 and not, pick one metric that the General Assembly can cherry pick. So the bottom line here is, on the Senate appeal, there's sort of two very simple points. First is the concession that the trial court didn't apply the governing standard, and that alone is reason to reverse. And second, even under the erroneously narrow legal standard, Mr. Strack did not dispute that the court just got it factually wrong, that there was no competent evidence to support its conclusion that a majority of advisors and experts concluded that the 1% mean median gap was satisfied. So even on the cherry-picked standards that the General Assembly focused on here, they didn't satisfy those standards. I think the legislative defense also argued that choosing what evidence the court should analyze as a policy decision. That's obviously not true. Setting out a legal test and analyzing the facts is a quintessentially judicial decision. The legislative defense wouldn't get deference on that, even if this weren't in the remedial phase. They didn't get any deference on that in the liability phase of Harper, and they certainly shouldn't in the remedial phase. And look, at bottom, the legislative defendants have made very clear that notwithstanding Harper 1, they continue to believe that the Constitution imposes no constraints on the redistricting process at all. The court said that they're wrong. They tried to do it again with the Senate and the congressional map, and this court should remind them that the North Carolina Constitution prohibits partisan gerrymandering and affirm on the congressional map and reverse with respect to the Senate map.
Your Honors, the remedial process here shows the wisdom of the court's decision in Harper 1 not to make a bright-line safe harbor rule, because as the competent evidence shows here, using such a bright-line rule would result in maps that deny substantially equal voting power to voters, maps that do not provide voters an equal opportunity to aggregate their votes to gain a majority. This is as true for the Senate, it is as true as well for the House. The Mattingly ensembles that were credited by the trial court and this court as well, show it would have been easy to get a map that scored better on partisan metrics without sacrificing neutral redistricting criteria. The political geography did not necessitate the amount of partisan skew in the House or Senate maps. If that had been true, it would have been difficult. And finally, to the extent that this court anticipated that fixing the partisan gerrymandering would also remedy the destruction of crossover districts that performed for Black voters, that did not happen, and it must be addressed now. Our Constitution requires a frequent recurrence to fundamental principles. If we are to give full force and effect to this court's February opinion, the court must strike down the remedial House and Senate maps. Justice requires it. Thank you, Your Honors.
Thank you. Other rebuttal?
Thank you, Your Honor. Briefly, the trial court did exactly what this court asked it to do. This court specified two metrics with two particular thresholds, and it said a court could use those. So this court ought not fault the trial court for doing exactly what this court advised it could do. The General Assembly then took that even more to heart and used it to ensure that it would draw objective maps that complied with what this court said the trial court could look at, and that would frankly be up the most manageable of all the standards that the court discussed. The General Assembly did that. They took that to heart, and the trial court deferred on the Senate, but not on the congressional, and why is inexplicable, but this court should certainly defer to the choices that the General Assembly made when they were trying to undertake this very difficult task. I would also point out that as to the point about whether one can draw a better map than another. Well, as this court has probably seen, experts and litigants can outdo each other on maps using these kind of metrics all the time. That's part of the problem. The plaintiffs say that's a feature, not a bug. I say that's a bug, and that's a real problem. But even Dr. Groffman, one of the special master's assistants, also disagrees that just having the best map is what matters. He said, quote, "A legislative map does not have to be the best possible map. The mere fact that a better map on multiple criteria exists does not require a court to choose that map over a map that is adopted through legal channels and due process." That's exactly what the General Assembly did in this particular instance, and the trial court should have deferred to all of its maps, and this court ought to do the same. Otherwise, this court is barreling into the political wilderness where the legislative authority to redistrict will be transferred from the legislature to the courts. The trial court's actions in this case regarding the congressional plan is a clear example of how this will happen. It is a clear example. So we ask the court to dismiss the congressional appeal per our motion and affirm the trial court's approval of the legislative plans. Thank you.
Thank you.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court.